And this is an excellent time to continue with the other speakers of this session and move to the law. And maybe common lawyers among us, we have a lot to learn from civil law systems or mixed systems. So Jonathan Brown, Scots law on this point, or more general?
Thank you, Michael. Yes, I know this is a very interdisciplinary conference, so I'm really kind of out of my element by talking about, I think, biology in the first instance here. I don't know if we have any biologists here, but certainly within the field of biology, taxonomy is extremely important. The classification of animals according to various kingdoms, domains, and the like. And I can't help but feel that part of the discussion that I think you yourself initiated, Michael, in the chat about the fact that in many legal systems there is a link between dignity and privacy is one which merits some degree of exploration, because in my video, what I was talking about really was the fact that in spite of Scotland's institutional connection to the civil law, there is a real reluctance to protect privacy in practice. And I think that that's one of the main things that we can detect at an elementary level of jurisprudence is a solid divide between what the law actually says and what society thinks it says, and how society acts in connection with the law. If you actually look at what the law says quite often, it can be quite horrifying. For instance, in Scotland, there is a crime known as plagium, which is the crime of child stealing, not kidnapping, literally the theft of a child below the age of puberty. Now, as a matter of fact in general practice, we don't treat children as though they are objects of property in Scots law. But when you actually look at what the criminal law says, the criminal law says that children are property. Now, that's absurd. That's one of the points that I think can be extrapolated not only to common law systems, but rather any uncodified system of law. There will be necessarily some effort involved in finding out what the law actually is, where any topic is concerned. But what this all rather takes me back to is the general point about these words that keep coming up: autonomy, privacy, memory, and so on, and how they are linked to dignity in certain legal systems. Well, I would say that what we as lawyers who are engaged and interested in the pure black letter law, and not all of us are, but I'm saying those of us who fit into that category, what we really ought to be doing is considering the law from a taxonomical perspective. We should be doing as Gaius did almost 2,000 years ago, essentially, and dividing the subject matter of the law according to areas of interest, yes, but within such a way that makes clear which domain each subject of study that we are concerned with lies in. I think that in the chat there has been some sort of discussion of the need to separate and divide between assets which can be regarded as property and those interests which are more non-patrimonial in character. Well, that's absolutely the case. So there should be, and there needs to be, a neat divide between patrimonial and non-patrimonial interests in any legal system. And I don't think that there necessarily is in the common law, or rather, I don't get the impression that there is in the common law. I wouldn't claim to speak for that because I'm not particularly familiar with how English lawyers think. But I can say that within Scotland, although there is, when you drill into it and look back to their institutional records, although there is this division of patrimonial interest being anything pertaining to the estate of a person and non-patrimonial interests, which Whitty and Zimmerman put beautifully when they said it essentially encompasses who a person is rather than what a person has. Although we have the general framework and schema for this, we don't use it, we forget about it in practice, and we suffer really in this jurisdiction from what I would term recent case-itis, which is that whenever a new case happens anywhere in the world, no matter how alien the concepts invoked in that case may be, we look at it and we think, okay, well, what lessons can we take from this case? And if there happens to be a new case, then we'll look to that new case and how does that contradict the last case? And that isn't really conducive to the kind of long-term thinking that I would argue that we need to apply in this area. Not even long-term, but more holistic thinking that we need to apply in this area. I think anyone with a familiarity with the Scots legal system is not going to be very surprised to hear me say this, but I think that there is a real need for us to consider, in the first instance, principles which govern the area as a whole, not to sequester things into silos and say, we are dealing with privacy as a particular interest, we are dealing with digital assets as a particular topic, but rather saying, okay, well, we're dealing with the law, we're dealing perhaps with something that straddles public and private law, but our appropriate response to that should be informed by asking, well, within the context of which area of law we're dealing with, how do we proceed once we have identified the appropriate area of law to invoke? So those are my general thoughts there. I did see there was a mention, well, in Scotland, we don't have what would be called a general remedy of vindication, but we do have a civilian concept of property law. Essentially, dominium or ownership is recognised as the sovereign or primary real right. It's much easier for us to point to a thing and say that thing is owned and it is owned by X, Y, or Z than I believe it is for English lawyers, where you have your more bundle of sticks approach to property. But I do have more that I've got to say in session 4, as I think Lillian said, and I'm conscious that other speakers have to get on and more.
Right. Sure. So thanks, Jonathan. I would just add to the complexity of the concept of property that every 5 years or so, there's a kind of a wave of scholars, American mostly, who argue that we should think about personal data in terms of property. Sort of, so that also kind of every now and then sort of muddles up everything once again.